short answer is no. 92% of automobile cases are settled before going to trial. And most of them settle at what we call mediation, which is scheduled at least 60 days before a scheduled trial date. Sometimes they settle before that. Sometimes they settle, on the eve of trial. But the chances are, in general, you will not have to go to a trial if you have a personal injury case. However, the more money involved in a case, the higher the claim, the greater the likelihood is that you might have to go to trial because the insurance company might want to contest certain parts of the claim. So what I tell people is that when you start with us as our client, there are really only 3 occasions that you'll have to have any input into the case yourself. One is to answer written questions, which are called interrogatories. 2 is to give your deposition, which is where you sit and the defense attorney asks you questions under oath with the court reporter. And 3 is to attend the mediation. And all the work that's done in between is done by us, okay? We take depositions of the other side's experts. We take depositions of the defendant. We send the written questions to the defendant. We do requests to produce documents. We evaluate the documents. So there are only 3 times as a client that you really have input into the process prior to having to go to trial. And so the chances are you will not have to go to court. But you have to be prepared to go to court. I tell all of my clients, never think that the case is going to settle. Always prepare for war if you want peace, if you will. And so we prepare for trial, and we never anticipate that the case is going to settle. We always prepare for trial. And I want my client to be ready to go to trial and make that commitment to me. And that's the way you get the biggest settlement.